in the case of Akhil Bharat Krishi Gauseva Sangh versus Union of India, it was held that while we respect traditional practice, the duty to prevent cruelty must prevail over them. Every traditional event involving animals must be conducted in accordance with the provisions of PCA Act. Your Lordship, these three rituals violates the PCA Act Section 11. Section 11 of PCA Act states that if any person beats, kicks, overrides, overdrives, or overloads, tortures, or otherwise treats animal so as to subject it to unnecessary pain or suffering solely with a view to providing entertainment or incites any animal to fight or bait any animal, he shall be punishable. Your Lordship, from the proposition itself, it is clear in the para 3 of the proposition that the animals used for these rituals are extremely inflicted injuries to them while performing these rituals. Your Lordship, if we go to para 8, as I said, the object of that particular act.
One more question.
Yes, Your Lordship.
If both the statutes can coexist, do you dispute that? Both the statutes can coexist in view of the provisions contained therein. One takes care of the cruelty caused to the animals, Prevention of Cruelty to the Animals Act is there. And these two statutes, these are basically to encourage sports activity. It doesn't encourage any kind of cruelty to the animals. So both the statutes can coexist. So why it should be struck down?
Much obliged, Your Lordship. Your Lordship, as I have said, these statutes can never coexist because these rituals are inflicted. They can never practice that taming rituals without hurting the bulls. Because if bull sleeps,
no, in course of such rituals, if any harm is caused or any cruelty is meted to the animals, that can very well be taken care of under the PCA Act, Prevention of Cruelty to Animals Act.
Much obliged,
if any kind of cruelty is caused to the animals, that scenario can be dealt with under the Prevention of Cruelty to Animals.
Your Lordship, that
so is why to strike down a statute? You have to justify.
Your Lordship, the PC Act 1960 has also been challenged under this under issue 5 because all the punishment available under PCA Act are non-cognizable and the punishments are very mere. Your Lordship, I would like to also say that in the case of Balli Singh versus Balli Singh, I would like to draw your attention to page para 38 of our proposition memorial, Your Lordship. That's the judgment of Odisha High Court in Balli Parida versus Neera Parida. A person has killed a cow, Your Lordship. A person has killed a cow because it entered into its that field where he has grown some crops. Your Lordship, it's very astonishing that the person went out of the hands of law just by paying a mere fine of ₹25. This is the provision which has been given under PCA Act 1960, Your Lordship. So we have also challenged this PCA Act that this is insufficient to address the cruelty that is being inflicted upon the animals. Your Lordship, in this 2020 we're living where internet reels are also trending. For some persons are for gaining views and being popular in the social media. There was a video where a boy threw a dog from the roof, multi-story building, and the dog died. And no action was taken because there are no deterrent measures which punishes this kinds of acts, Your Lordship. That's why we have also challenged that particular act in issue number 5, Your Lordship. All the punishment have been made very negligible. They can maximally, all the offenses are non-cognizable. They can claim bail as their right, Your Lordship. The definitions of the punishment has not been also defined. So we have also challenged that in issue number 5, Your Lordship. Your Lordship, in catena of judgments also, I would like to refer Animal Welfare Board of India versus A. Nagaraja. It was held that right to dignity and fair treatment is therefore not confined to human beings alone, but to animals as well. Right not to be bitten, kicked, overrider, overloading is also a right recognized by Section 11. Also, it has been said that penalty for violation of those rights are insignificant since laws are made by humans. Punishment prescribed in Section 11(1) is not commensurate with gravity of the offense. Your Lordship, the offences has been also not...
Mr. Counsel, can I answer this question? A farmer, he has 2 bullocks,
yes, Lordship,
for his plowing purpose, right? while he is doing his plowing, he hits these bullocks. Can it be considered to be cruelty to the bullock?
Much obliged, Your Lordship. That is the reason the PCA Act needs to be repealed. There are two things I would like to draw. First one is the section itself says that unnecessary pain shall not be inflicted. So necessary pain is allowed because welfare of...
Does it come within the purview of this necessary pain?
May I answer it, Your Lordship? Your Lordship, it is said that welfare of the people is the supreme law, Your Lordship. Animals can be used for the welfare of the people. God also, it has been many times it has been said human beings are the supreme in this earth, so they are the they can control over the animals, they have control over the space, they have control over the moon. That's why they can use it for their own purpose, which is in view of morality, we can say. If it is not ethical, we are using it for bed. Since we are saying that in the proposition itself, it has been said that it is a part of our culture. Your Lordship, I would like to draw your attention. Just because it has been practiced for mere 500 years, we are saying that it is a culture.
But don't skip the question.
No, Your Lordship, I'm not skipping the question. I'm just saying that.
I have I put a very pertinent question to you. You have to answer that. So can it come within the purview of the PCA Act?
No, Your Lordship, it can't.
Why?
Because itself in PCA Act, it has been...
The farmer has already bitten
Your
while
Lordship,
plowing, and he had to sustain injury also at times. Why it not considered as cruelty?
Your Lordship,
You are recommending two different yardsticks, one for the farmer and another for Jallikattu.
Much obliged, Your Lordship.
There it will be cruelty, here it will not be cruelty.
Much obliged, Your Lordship. Your Lordship, the basis is first, our legal system is like that, the welfare of the people shall be supreme law. So for the welfare, for the food, he is beating the bulls. So bulls, if he is taking care of them, he is feeding them. So bulls are made for those works. So if he can't...
Likewise, for food, they can also eat animals.
Your Lordship, PCA Act has provided the
justify that for food they can do whatever they want to. They can eat animals also. Then why this is Prevention of Cow Slaughtering Act?
Much obliged. As Your Lordship, as India is a multilingual country and also a large population of India believes in Hindu religion, and here cows are worshipped, Your Lordship, as a mother. Cow have been given a position of a mother, so it should not hurt their feelings, it should not hurt the feelings of our fellow brothers and sisters. That's why it has been banned, Your Lordship. Lordship, also, like for the food we are eating also hen, we are eating goat, it is permissible. It is permissible by the PCA Act only. So there are exceptions where we can use them as a food because our existence is first, because we humans are controlling this earth. May I proceed, Your Lordship?
If it is for sports purpose?
Much obliged, Your Lordship. Again, if Your Lordship, if I refer to since I have been saying that this is not a culture, this is not a part of our culture, because our culture says...
You must have witnessed the film Swale?
Yes, Your Lordship, I have witnessed.
No, you have to. There, Basanti was driving hard to this horse. What will happen to that?
Your Lordship, again, that is for transport. Section 11 of the PCA Act saying it should not overload them. We can use it for our purpose. Your Lordship, as we said, for entertainment purpose we cannot use, because these rituals are merely 500 years. Our scripture says, what our scriptures, like if we refer to Quran says animals cannot be used as a bait for the entertainment purpose, or they cannot be used for it has been prohibited. Our scripture says, if we refer to like Sarve Bhavantu Sukhina Sarve Santu Niramaya Sarve Bhadrani Pashyantu, in that it is saying we should love all. There has to be for compassion for all living beings. It has never been said that the compassion should only be for persons. It has said for all living beings. So these animals are also having lives. So how can we restrain them from enjoying life? Because just because they are voiceless, they are weak, they are infirm, they are unable to file a PIL in front of this honorable court, we have to do this because it is the duty of the court.
Forget about the rituals. In the early morning, do you go for a morning walk? Have you seen people with pet dog?
Yes, Your Lordship.
What do?
They if dogs or stray dogs come to near them,
No, they go with the dog. What do they do in parks and some other areas, open areas? Don't they play with their dogs?
they play.
Then is that not violative of their right, so-called their fundamental right?
Much obliged, Your Lordship. But in that, no animal is being hurt, Your Lordship. No, here the proposition itself says sometimes it is causing death of that animal. But I have never heard of any incident where a person has bitten a dog to death by its baton. It's very rare, Your Lordship. But in this case, there is an established fact in the proposition itself that animals are dying in this. If you may, for the appreciation of the court, he may refer to paragraph number 4 of 3 of the proposition, Your Lordship. It clearly says that bulls are often beaten to increase their aggression and subjected to grueling physical demands leading to injuries and even death, Your Lordship. It's very clear. So in the name of rituals, can human beings inflict pain on these voiceless animals just because they can't speak, just because they are weak and infirm? So it is our duty, Your Lordship, it is duty of our court to give them the right to life, which has been extended in many category of judgments, Your Lordship. Your Lordship, may I proceed with issue number 3 of
Yes.
4?
Yes.
Much obliged, Your Lordship. Your Lordship, issue number 4 states whether the imposition of section 163 of INSS in Ranthara and Dharmaraja proportionate or it amount to abuse of power by suppressing legitimate dissent and free expression. Your Lordship, the petitioner here most humbly submits that the imposition of 163 INSS is disproportionate because it has been used to suppress the voice of dissent. The government has used it to suppress illegitimately to suppress the voice of dissent. If some restrictions would have been imposed, it should have been imposed on the wrongdoer. Here, the journalist who made an effort to bring out the truth in front of the society by filming a video or by making a documentary, his voice was suppressed, Your Lordship. Hence, I believe that this particular utilization of power under 163 was disproportionate. I would like to refer to a judgment of joint platform of doctors and others versus state of West Bengal and others. Your Lordship, prohibitory orders under section 163 were imposed to prevent junior doctors from protesting the brutal murder of a fellow doctor during the Durga Puja celebration in Kolkata. Your Lordship, the Kolkata High Court set aside the prohibitory orders, stating that they unjustly restrict the fundamental rights to assembly and expression guaranteed under Articles 19(1)A and 19(1)B. Your Lordship, just because I am protesting because I feel something has been wrong and some other group is coming and clashing with us, the government cannot put restrictions on my speech and expression. They should rather stop them from encroaching upon my rights that have been guaranteed under the Constitution, Your Lordship. Your Lordship, further, I would like to go to issue number 5, which is I have already roughly said to you. Can I proceed with issue number 5, Your Lordship?
Yes.
Much obliged, Your Lordship. Your Lordship, whether the provisions of Prevention of Animal Cruelty Act is sufficient to address the cruelty on the animals and provide sufficient punishment required an amendment. Your Lordship, it is most humbly submitted that the PCA Act 1960 is insufficient to address the cruelty on animals and provides insufficient punishment and require an amendment, Your Lordship. Your Lordship, the penalty prescribed for acts of cruelty under section 11 is maximum fine for first time offender is merely 50 rupees, which is grossly disproportionate to the severity of many offences. Your Lordship, the maximum penalty increases only to rupees 100 with imprisonment not exceeding 3 months. Such trivial fines do not serve as a deterrent. Instead, they trivialize the severity of animal cruelty, allowing perpetrators.
Sorry to interrupt your lordships. Your lordship, speaker 2 time is already over. If this honorable court permits, then only we can allow.
Yes, wrap up within 2 minutes.
Much obliged.
Your lordships.
I will wrap up in 2 minutes. Your Lordship, as per the Mallimath committee, it also suggested that the punishment are to be revised, otherwise they do not meet the purpose and become obsolete. Your Lordship, also it is said that the court also should be vigilant to see the benefits conferred by such remedial and welfare legislation. Court has got the duty that in every case where ingenuity is expanded to avoid welfare legislation, to get behind the smokescreen and discover the true state of affairs. Your Lordship, as I said, the offences are bailable and non-cognizable offences, and the penalties are outdated. Also, there is lack of differentiation in offences. No classification of severity has been given. The PCA Act fails to differentiate between various degrees of cruelty. All forms of cruelty are treated
differently. PIL. Is it PIL?
Yes, Your Lordship.
PIL?
Yes, Your Lordship.
How will a person agree?
I beg your pardon. Can you repeat?
How will person agree?
Person agree. Your Lordship.
Now, I'm raising a question of locus.
I understand, Your Lordship. This is the locus standard. Your Lordship, as I already said, that I am a Animal Welfare Board Association. I am, Your Lordship, NGO of People for Animal. So I am responsible, since I am an NGO, non-government organization who is responsible for the animal rights. So I have the locus standi, Your Lordship.
Locus standi question in PIL. Is there any decision that question of locus standi not arise in the question of in the PIL?
Yes, Your Lordship. I don't remember the case law, but it is there in PIL cases there is no need of locus standi in it.
Counsel, when you file the application, you must see whether it is a PIL or whether it is a person aggrieved has filed this application or not. How he is being aggrieved. These have to examine first. You are arguing a matter. First, you have to see your locus. How my rights have been infringed. So in a PIL matter, question of locus initial is there, but now it's no more there.
It's not there.
Right? Now
Yes,
it's no more there. So the question is that even if you are an association, you can also file. Now another question you can raise the question, say that whether association can pursue the matter.
Yes, Your Lordship, it can.
Why? How? Suppose a service association. Service association can they pursue the matter for claiming a benefit of a particular individual?
No, Your Lordship. No, Your Lordship.
Why? You say now yes, now you say no.
No. I said that this NGO can pursue the case of the animals. I said.
Then. I say if the same principle applies, then why not to the service matters?
Service matter. I plead your ignorance, Your Lordship. I don't have that idea.
All right.
Proceed.
Much obliged. Your Lordship, that's it. So, in the Compassion Unlimited Plus versus Union of India, it has also been said that unnecessary pain and suffering is an offence under Section 11 and 3. There is a need for clearer definition and stronger penalties, Your Lordship.
All right, time over.
Much obliged, Your Lordship. Much obliged. Thank you.
Thank you so much. Thank you.
Thank you.
The counsel seeks permission to stand and appear before the bench, Your Lordship.
All right.
Obliged, Your Lordship. The counsel seeks permission to begin, Your Lordship.
Yes.
Obliged, Your Lordship. The counsel seeks permission to address the bench collectively as Your Lordships.
You are free to make your address. It doesn't require any permission.
Certainly, Your Lordship. Obliged, Your Lordship. A very good morning to the honorable members of the bench. My co-counsel and I appear on behalf of the respondents, Union of Indica, in the present matter. Your Lordship, the Supreme Court has framed 5 issues for the dispute at hand, and I would be dealing with issues 1 and 5, and my co-counsel would be dealing with issues 2, 3, and 4. I would be taking 29 minutes, and my co-counsel would be taking 29 minutes, respectfully reserving 2 minutes for rebuttals. During this time, we would be making our commitment.
As of now, you have not said you are representing whom.
Your Lordship, I stated that I appear on behalf of the respondents, Union of Indica, in the present proceedings.
All right.
Your Lordship,
You are a state counsel now.
No, Your Lordship, I am representing the state of Indica.
Right.
That's right. That's the state council. That's what Malad Suddenly said.
Certainly, Your Lordship.
So you are representing the state council.
Yes, Your Lordship.
So you are justifying your action.
You are the Solicitor General of India. So now you are.
30, your lordship.
Now you are
Yeah.
justifying your action taken under the parliamentary provision of 144.
Your lordship, my co-counsel will be dealing with that issue in specifics. Your lordship, during this time of 1 hour, we would be making our submissions as well as replying to the submissions of the petitioners. If your lordship may permit, the council would like to state the facts in brief before moving forward with the submissions.
Yes.
Your lordship, Indica is a nation known for its secular values and demonstrates great respect for all religions, which extends to the worship of animals in certain regions. Among its diverse cultural practices, the states of Ranthara and Dharmaja are particularly celebrated for its traditions rooted in the agrarian and spiritual beliefs. In these states, bulls are often considered symbols of strength, fertility, and prosperity. Rituals such as Vardhani bull races, Govishya trampling ritual play an integral part in their cultural and religious landscape, performed to seek blessings for abundant harvest and communal well-being. These ancient practices show a deep reverence for the earth and divine powers. Your lordship, the Vardhani bull race, a 500-year-old tradition in Ranthara, was initiated as a thanksgiving ritual to the rain gods after the harvest. Dharmaja's Govishya trampling ritual, which is held post-Diwali, is an act considered spiritually purifying. Your lordship, state government of Ranthara and Dharmaja implemented section 163 of INSS, banning public gatherings and imposing internet shutdowns to prevent the spread of inflammatory content by the video of bulls of sorrow. In a bid to address the concerns while preserving tradition, both states enacted new laws, the Ranthara Bull Sports Regulation Act and Dharmaja Cultural Heritage Act 2023. Your lordship, these laws establish sufficient safeguard to prevent cruelty and maintain that the rituals were fundamental to their cultural identity. Despite these new regulations, legal battles continued. Animal rights organizations filed public interest litigations in the high courts of Ranthara and Dharmaja and Velakam, asserting that these practices violate the right to life under Article 21 and 51 AG of the Constitution. If your lordship may please, the council now seeks permission to move forward with the submissions with respect to issue 1.
Yes.
Much obliged, your lordship. Your lordship, the first issue deals with whether the Ranthara Bull Sports Regulation Act and the Dharmaja Cultural Act conflict with the Prevention of Cruelty to Animals Act and violates provisions of the Constitution of Indica or not. The council in this regard respectfully submits that the Ranthara Bull Sports Regulation Act and Dharmaja Cultural Heritage Act do not conflict with the Prevention of Cruelty to Animals and the provisions of Constitution of Indica. Your lordship, I would be dealing with this issue in 2 prongs. Firstly, the acts are enacted for the purpose of cultural preservation within constitutional and legislative frameworks. Secondly, these acts are regulatory in nature and align with the Prevention of Cruelty to Animals Act's objective to prevent cruelty to animals and therefore is not violative to the Central Act. Substantiating further upon my first prong, it is submitted by the council that the Yuvata bull taming ritual, the Vardhani bull races and Govishya trampling ritual were enacted to protect the cultural heritage of the regions, where these practices are rooted deeply in the agrarian traditions of the local communities. I would like to draw your lordship's kind attention towards the Moot proposition para 2 line 1, para 2 line 4 and para 3 line 1 to substantiate it. If your lordship may allow, if your lordship wants, I could recite the fact sheet with respect to the statements I am making.
Yes.
Certainly, your lordship. Your lordship, when we go towards Moot proposition para 2 line 1, it specifically states, meanwhile, for centuries, in Indica, the states of Ranthara and Dharmaja have been celebrated for their vibrant cultural traditions, deeply rooted in their agrarian lifestyle and religious beliefs. Your lordship, when we come to the line 4 of the same paragraph, it states, the Vardhana bull races of Ranthara and Govishya trampling ritual of Dharmaja are 2 such ancient practices where bull plays a central role in festivals that are said to honor the earth and gods, seeking blessings for abundant crops and strong community.
Can't you hear me? the objection was that you put a restriction by invoking the provisions contained under Section 144 of the CRPC, according to that BNS Act, whether the state has got such a power to impose such restriction or not.
Your Lordship, you were not audible in the beginning. Could you please repeat?
You have to justify the state's conduct of taking action under 163 of BNSS.
Your
Alright?
Lordship,
Which is 143, parameter provision of CRPC. That's
certainly, Your
what
Lordship.
Justice Shorting has asked.
Your
being
Lordship,
being a state council, in your reply, you have to be very specific, very focused. You have to rebut the arguments raised by the petitioner's counsel. All right?
Your Lordship, in this regard, my co-counsel would be defending that argument. That action was taken as a reasonable restriction under Article 19, Clause 2. To further substantiate it, my co-counsel would be dealing with. Allow me, I would like to move forward with my submissions.
Yes.
Your Lordship, if I may draw your Lordship's kind attention to Moot Proposition Para 2 Line 3. In these lands, the bull has always been revered not just as a beast of burden, but as a symbol of strength, fertility, and prosperity. Your Lordship, in a land where bulls are worshipped, it can be stated that the inherent objective of these festivals or cultural practices is not to harm bulls in any way. Your Lordship, we understand a video by the name of Bulls of Sorrow has surfaced, and Your Lordship, the brutality as shown in the video is the reason that we have come up with state legislations. Your Lordship, it is submitted on the behalf of the respondents that a blanket ban on the rituals, culturally so important, continuing from over 500 years, should not be the discussion in front of this bench, Your Lordship. These rituals symbolizing communal identity and agricultural reverence are safeguarded under Article 29 of the Constitution, which protects cultural diversity and provides the right for citizens to conserve their heritage and culture. Your Lordship, though the marginal note of Article 29 mentions minority rights, the rights conferred by Clause 1 are not restricted to a political minority in the state, Your Lordship. Your Lordship, the view of the Supreme Court in a number of judgments such as TMA Pai versus State of Karnataka, if I refer to the judgment, page number 555, para 89 states that it extends to any section of citizens as enshrined in the bare text, whether they belong to the minority or the majority community. The only condition being that such section must have a distinct language, script, or culture of its own, which we can see that the community, according to the fact sheet, has definitely a vibrant culture of its own. The enactment of these state acts is thus a lawful exercise of the legislative power, balancing the state responsibility to protect cultural practices with obligations to prevent animal cruelty. The councils on behalf of the respondents respectfully contend that banning these traditional practices would infringe upon the community's constitutional right to conserve their cultural identity and heritage, which is essential for social unity and pride in the state's legacy, where rituals such as Vardhani bull races date back over 500 years.
So is it your contention that both the acts are intra-virus of the state constitution?
Certainly, Your Lordship, these acts are not ultra-vires of the Constitution, Your
And
Lordship.
one additional question to what Dr. Justice Sarangi has asked: does it take care of that cruelty aspect? While permitting the sports activity, does the statutes, both the statutes, does it take care of the cruelty aspect?
Certainly, Your Lordship, it does take care
of the
of it.
provisions.
Certainly, Your Lordship,
Which
if
are
I
the
may
provisions?
refer you,
Mr. Counsel,
if I may refer,
you should not begin sentences certainly. How can you are arguing matter with the court? It's not certainly. Don't do that. Heaven's sake, don't do that. Don't make statements certainly. It's not required. It's not. You are not addressing public field. You are addressing the court, right? So don't
much
make,
obliged. Much obliged, Your Lordship. I'll take care. Take a note of that.
yeah.
Your Lordship, if I may refer you to, clarification number 10 which was released by the committee. Your Lordship, it specifically states.
Which are the
Your
provisions in those two statutes which are
Your
under
Lordship,
challenge?
certainly, Your
That
Lordship,
take
the
care of, that
clarification.
aspect. Show us the
Your
provision. Show us the
Your
provision in those two statutes which takes care of this scenario. Any cruelty to the animals in course of
Your Lordship, according to the Your Lordship, according to clarification number 10, it specifically states the provisions, which is firstly, mandatory veterinary checks for animals would be done. Secondly, limitations on the methods of provocation. Thirdly, ban on sharp objects. Fourthly, supervision by local communities to ensure compliance. Your Lordship, these are some of the provisions that I can point out at this point of time for Your Lordship to refer to.
And then what are the preventive provisions if somebody still indulges with cruelty? Any penal provision?
Your Lordship, if Your Lordship, according to clarification number 18, we can draw parallel with the real act of Tamil Nadu Jalaikattu Regulation Act. According to this Regulation Act, Your Lordship, there are penal structures also to this act.
Well, Jalaikattu Act applied to your case or not?
Yes, Your Lordship, it can be applied to our case as the fact sheet specifically states in para number 5 that the Uvanta bull teaming ritual is akin to the Tamil Nadu's Jalaikattu.
That provision under that act is there. No problem for that. You are dealing with the two acts which you promulgate. So whether such a provision, permitted provision available to your act or not, that my brother Justice Mohapatra is asking.
Your Lordship, according to clarification number 18, we were allowed to draw parallels between the Ranthara Bull Sports Regulation Act, Dharmaja Cultural Heritage Act, and Tamil Nadu Jalaikattu Regulation Act. Therefore, Your Lordship, the Tamil Nadu Jalaikattu Regulation Act has penal provisions. Therefore,
can the penal provision available in Jalaikattu Act will apply to your state?
Your Lordship,
the scope of Jalaikattu Act?
Your Lordship, the scope of Jalaikattu Act is specifically to the state where Jalaikattu was being practiced, Your Lordship.
Correct. Therefore, it is applicable to Tamil Nadu only. Now,
certainly,
now question is the two acts which are under challenge, whether such a provision is made available under these acts or not. You say Jalaikattu will apply. If that provision is there, then only can I apply, other than that.
Your Lordship.
What was the necessity of having these two additional acts? Jalaikattu Act takes care of the scenario. What was the necessity of having two additional statutes?
Your Lordship, the necessity, firstly answering in series the questions, Your Lordship, there is no specific mention of penal provisions in the fact sheet. Secondly, Your Lordship, the importance of bringing state acts is that the specific practices that are being practiced in these states, Your Lordship, these are giving rise to some miscreant people who are harming the bulls. Therefore, to protect those bulls and animals, we have come up with state legislations. Your Lordship, these state legislations are specific to that state and therefore protect the cultural identity as well as maintain balance by protecting the animals from cruelty. Your Lordship, if you're satisfied with my answer, can I move forward with my submissions?
Yes, we are satisfied on that we are not answering you. We are not hearing you.
We are taking note of your contentions. So your judgment will say how far you are convincing.
Sure.
So therefore, you proceed.
Your Lordship, the enactment of these state acts is a lawful exercise of legislative power. The Council, on behalf of Respondent, respectfully contend that banning these traditional practice would infringe upon the constitutional rights. Your Lordship, the rituals provide local communities with a sense of continuity and connection to the ancestral roots. And without these cultural expressions, citizens would lose a vital part of their heritage. The Ranthara and Dharmaja Acts therefore ensure that these cultural rights are protected and a reasonable balance between cultural preservation and human treatment standards of the animals is maintained, Your Lordship. Your Lordship, it should be placed on record on behalf of the respondents that importance of cultural rights is not only recognized by the United Nations Declaration on the Rights of Indigenous People, which India is a signatory to, but also, Your Lordship, by this court in a number of judgments, such as K.R. Ramaswamy @Traffic Ramaswamy versus State, Pramati Educational Cultural Trust versus Union of India, and there are a lot of judgments, Your Lordship. If Your Lordship, the state legislations brought to question.
If you are referring to certain judgments, you must tell the fact of that case, then how it is applied to your case, that must be placed for us. Otherwise, how can I appreciate that what you are saying is the same thing? Just giving citation will not solve the purpose.
Summarily, what has been decided? In a brief note, you have to refer, this is what has been decided. Therefore, I rely upon those laws laid down or issues laid down in those judgments. So it will be more convincing.
Oblige, Your Lordship. Your Lordship, in the K.R. Swamy, which is Traffic Ramaswamy versus State, the facts were that the government of Tamil Nadu enacted the Tamil Nadu Tamil Learning Act, mandating Tamil as a compulsory subject for students in standards 1 to 10. The plea challenged the act, arguing it infringed on linguistic minorities' right under Article 29 and 30 of the Indian Constitution. Your Lordship, the court in this respect held that the Act does not violate the right of linguistic minorities under Article 29 Clause 1 and Article 30 Clause 1 and dismissed the petition, finding no malified intention of the state for minority rights, Your Lordship. Your Lordship, referring to the other judgment, which is Pramati Educational and Cultural Trust versus Union of India, a private, unaided minority schools challenge the constitutionality of the right to children of Free and Compulsory Education Act 2009, specifically sections mandating to education for economically weaker sections. They argued that these provisions infringed minority institutions' right under Article 30 Clause 1 of the Constitution to manage their institutions independently. Your Lordship, the Supreme Court held that applying the Right to Education Act to minority institutions violates Article 30 Clause 1 as it interferes with their autonomy. Consequently, minority institutions were exempted from the RTE Act, Your Lordship. But whereas, Your Lordship, the general statement made by the Supreme Court in this case was that importance of cultural rights is not only importance of cultural rights should be recognized based on depending on the type or the structure of the society according to the factual matrix, Your Lordship. Your Lordship, now the state legislations brought to question enables the preservation of culture without infringing upon animal welfare obligations. This regulated approach reflects the state's commitment to maintaining cultural diversity within legal and ethical parameters, Your Lordship. Your Lordship, the Council on behalf of the respondent submit that there is no question of repugnancy in the dispute at hand. Your Lordship, it is our contention that the state legislation complements the Prevention of Cruelty Act rather than contradict it. If Your Lordship may grant his kind attention to clarification 10 at page 2 of the clarifications released for the Moot proposition, the Ranthara and Dharmaja Acts introduce rigorous safeguards, including mandatory veterinary checks, limitation on methods of provocation, ban on sharp objects, and also to ensure compliance supervision by local authorities. Your Lordship, by addressing potential cruelty proactively, the states ensure that animals are treated humanly, allowing cultural practices to continue within a framework that prioritizes animal welfare, therefore aligning the state legislation with the objectives of the Prevention of Cruelty Act. Your Lordship, the Council on behalf of the petitioners contended in their para 4 of the written submissions that Prevention of Cruelty to Act is a welfare legislation, also further stating in the last line that the entire animal kingdom includes birds and aquatic animals and have a right to life and are entitled to legal protection. Also citing the case of State of Uttarakhand versus People for Animals, whereas Your Lordship, I would like to bring your kind attention, there does not exist any such case. The SCC citation they have used is of the case Narayan Dutt Bhatt versus Union of India. Your Lordship, also, I would like to bring your kind attention to the written submissions of petitioners, para 4, where they contend that animals have right to life with dignity, citing the Supreme Court judgments, PETA versus Union of India, the judgment of 2017. Your Lordship, whereas there does not exist any judgment in the year 2017 of the PETA, rather of 2016 and 2018. The citation being used is of the Sabrimala case, which is India Young Lawyers Association versus State of Kerala. Not only this, Your Lordship, on page 14 of the submission, they contend that just as humans are entitled to these protections, animals have the right to live free from unnecessary harm, citing the judgment of Nair Services Society versus Union of India. Whereas, Your Lordship, even such judgment does not exist. And the citation being used is of a judgment named Mithu Pasi versus State of Jharkhand. Also, Your Lordship, which this case does not relate to animals at all, rather relates to section 326 of CRPC. Whereas, Your Lordship, if you may allow, I would like to present my case compendium with respect to the judgments of Animal Welfare Board of India versus Union of India, the 2023 judgment, Your Lordship. If Your Lordship may allow, may I share my screen, Your Lordship?
Yes.
I would request my researcher to share the screen. And
Just a minute. Except speaker number 62, other speakers may sit down. Why are you standing? While addressing you, was asked to make submission by standing. Other speakers may sit down.
Understood, Your Lordship.
Otherwise, you will be alleged of cruelty to councils.
Your Lordship, I hope my screen is visible, Your Lordship.
Yes.
Your Lordship, going to page 367, para 29 of the judgment. The Constitutional Bench of the Supreme Court in 2023 cited that there exists no precedent for the same, Your Lordship, and did not give the fundamental rights of Article 14, 21 or 19 to the animals, as it would result into judicial adventurism, Your Lordship. Whereas the petitioners have cited cases by making cases, Your Lordship, which do not have any SCC citations, rather citations of some other cases, Your Lordship.
You are referring to para 29.
Your Lordship?
You are specifically referring to para 29 of that judgment.
Certainly, Your Lordship.
What has been decided?
Your Lordship, the Constitutional Bench of the Supreme Court has stated that there exists no precedent for same for giving fundamental right of life to animals and did not give fundamental right of Article 14, 21 or 19 to the animals, as stating it would result into judicial adventurism.
To be invoked by any animal as a person.
Your Lordship, you are not audible. Could you?
You should have highlighted that portion of the judgment.
Your Lordship, it starts from para 29.
Towards the bottom. I think fourth line from the bottom. We do not think Article 14 of the Constitution of India can be invoked by any animal as a person. That thing.
Also that, Your Lordship, para 29, line 1, Your Lordship. On the question of conferring fundamental rights to animals, we do not have any precedents. Your Lordship, citing now line number 3. The only tool available for testing this proposition is interpreting the 3 Amendment Acts on the reasonableness in Article 14. Your Lordship, Your Lordship, also referring to the 4th last line, we do not want to venture beyond this and leave the exercise to the appropriate legislative body. We do not think Article 19 of the Constitution can also be invoked by any animal as a person. While also, Your Lordship, I would like to refer to line 5. While the protection under Article 21 has been conferred on persons as opposed to citizen, which is in the case of Article 19, we do not think it will be prudent for us to venture into judicial adventurism to bring bulls within the said protected mechanism, Your Lordship. And Your Lordship, this is a 2023 Constitutional Bench, Supreme Court Constitutional Bench.
is it your contention that the argument advanced by the your counterparts that the provisions contained in both the acts is violative of Article 26, 25, 26 is contrary to the Article 21?
Your Lordship, we contend that the provisions of the state acts are not in contravention to any of the articles of the Constitution, Your Lordship.
Correct.
Your Lordship, these state legislations are in the nature of, if my researcher could
No, this
just stop this
constitution bench,
statement.
just a minute. This constitution bench judgment which you have shown in your screen,
Certainly.
what was the facts? What was the issue involved in that?
Your Lordship,
Summarily.
Your Lordship, the issue involved in the present case was of three disputed acts which tried to regulate sports in the same manner as the impugned dispute at hand does. Your Lordship, in this is a case of state of Tamil Nadu with respect to Jallikattu.
Jallikattu.
Your time,
Your Lordship, I seek 5 minutes of extension, Your Lordship.
5 minutes will not grant because you have granted 2 minutes only.
You get only 2 minutes. Article 14.
Sure, Your Lordship. Your Lordship, these state legislations are in the nature of reformed legislation in the Supreme Court's view in the Constitutional Bench. Your Lordship, Your Lordship, the Council seeks permission to move forward with issue 5.
Yes.
Your Lordship, it is the contention on behalf of the Council of Petitioners that the provisions of the Prevention of Cruelty Act are sufficient to address the cruelty. This contention is humbly advanced in two-pronged manner. Firstly, the Act's provisions effectively address animal cruelty. Secondly, there exists adequate penalty to deter and redress offences through the Act and its associated rules. Your Lordship, we also fail to believe that that the learned petitioners on behalf have also been citing the provisions of Prevention of Animal Cruelty Act to safeguard bulls, and now contend that this act is not comprehensive and needs amendment. Your Lordship, I would like to reiterate some provisions of the Prevention of Cruelty to Animals Act to elucidate that this act is comprehensive. Yes. PCA Act imposes a mandatory duty under Section 3 for individuals responsible for animals to ensure their well-being by taking all reasonable measures. Chapter 3 from Section 11 to 13 specifically addresses cruelty to animals, with Section 11 being the most significant provision due to its penal nature and its benefit to animals. Your Lordship, Section 4 of the Act makes a provision for establishment of Animal Welfare Board of India, which is tasked with promoting animals. If Your Lordship may refer to page 35, para 64, para 65, para 66 and 67 of the written submission on behalf of the respondents, Your Lordship may see that the state of Indica has also come up with associated rules with the PCA Act. Breeding of and Experimentation on Animals Rules 1998, Transport of Animals Rule 1978, Prevention of Cruelty to Animals Rules 2001, Performing Animal Rules 1973. Not only this, Your Lordship, also on 7 January 2016, a notification by Ministry of Environment, Forest and Climate Change bearing number GSR 13E included bulls as well in the definition of performing rituals according to the Act and gives it additional safeguards in the PC Act. Your Lordship, not only this, we have enacted other provisions for animal protection and animal welfare, such as, Your Lordship, Section 325 of BNS, which is equivalent to Section 428 of IPC and 429 of IPC, addressing mischief by killing, poisoning, maiming, or rendering useless any animal shall be punished with imprisonment of either description for a term which may extend to 5 years, or with a fine, or with both. Not only this, Your Lordship, we have certain acts in place, namely Wildlife Protection Act, which punishes violations impacting the wildlife, prescribes up to 3 years of imprisonment or a fine of 25,000.
It's not wildlife. It's not a question of wildlife. It is you are not dealing with the wildlife here. The Wildlife Protection Act cannot apply.
Your Lordship, if we consider the Prevention of Cruelty to Animals Act, we should not be specifically restricting ourselves to states of Randhara and Dharmaraja and these practices. We should also be taking into account the state of Indica, where, Your Lordship, there can be other methods of giving harm or cruelty to animals, and therefore, Your Lordship, specific state acts were enacted for this, and the central legislation still remains prevalent. Your Lordship, if the bench is satisfied with my submissions, I would like to invite my co-counsel for their submissions before this esteemed bench.
All right.
It was an honor arguing before this bench, Your Lordship.
All right. Thank you so much.
Thank you.
Yes.
Greetings to the bench. Your Lordships, am I audible?
Yeah, yes.
Much obliged, Your Lordship. Your Lordship, the Council seeks permission to proceed with issues 2, 3, and 4, wherein issue 2, the Council will proceed with why these rituals should be protected as cultural rights, and for reasonability of internet bans and imposition of Section 163, the Council will give submissions under issue 3 and 4.
Yeah.
Much obliged, Your Lordship. Your Lordship, proceeding with issue 2, it's most humbly submitted that these bull rituals can be protected as cultural rights while fulfilling the duty to prevent cruelty to animals. Your Lordship, moving forward with the argument, the petitioners contended that essential religious practices are those which constitute cornerstone of a religion and not some alterable religious practice. Your Lordship, if I may have Your Lordship at para 2, para 3, and para 4 of the Moot proposition. The Council can read out the relevant lines.
Yes.
Understood, Your Lordship. Lordship, para 2 mentions that the Vardhani bull races and the Govishya trampling rituals are ancient practices which honor the earth god and seek blessings for abundant crops and strong communities. Para 3 mentions that the Vardhani bull races date back over 500 years and they are in the form of thanksgiving to the rain gods. And the Govishya trampling ritual is conducted the day after Diwali. Your Lordships, the state of Ranthara and Dharmaja are agrarian states. All these rituals are to worship the gods and the earth, and they are for abundant crop. Therefore, they do qualify as essential practices. Furthermore, Your Lordship, paragraph 5 states that Velakam Siota bull taming ritual is a sport which has found, it is akin to Tamil Nadu's Jallikattu. Your Lordship, these sports are in the form of young men taming bulls, and these sports have found reference in various ancient texts and artifacts. Like there are rock paintings and there are archaeological seals which depict these scenes. Furthermore, Your Lordship, the counsel for the petitioners argued that in the case of Animal Welfare Board of India versus A. Nagaraja, 2014, Volume 7, SCC, page number 547, the judgment stated that at that time, the practice of Jallikattu did not form a part of culture. However, Your Lordship, the council would like to argue that facts of that case do not apply to the present situation. At that time, the Tamil Nadu Jallikattu regulation was challenged because the practice in which the form in which Jallikattu was being practiced was cruel. However, in our case, the manner with the implementation of Ranthara Bull Sports Regulation and Dharmaja Cultural Heritage Regulation, these are two acts which aim to regulate the offending elements of these sports. As stated by my co-counsel, these regulations bring various safeguards for the animals, such as veterinary treatments and prevention of provocation and prevention of using sharp objects. The council also stated that bringing regulation is a form of giving cigarettes and then giving medical treatment. However, Your Lordship, at the first place, it's not like we are first harming the bulls and then controlling. At the very outset, the main aim of the regulation are to prevent all the offending activities which are subjecting the bulls to irritants, provoking them, aggravating the bulls. These are the elements which will be eliminated at the first half. So there will be no provocation or harm to the bulls, and this is what the regulation aim for. And moving forward, Your Lordship, the petitioner cited the case of Durga Committee Ajmer versus Syed Hussain. Citation was AIR 1961 SC page 1402 to say that religious practices must be essential. However, Your Lordship, this same case also said that state can regulate the practices which are superstitious or unessential, which is what the state is doing at the present scenario. These regulations which have been enacted, they will significantly transform the practice and execution of these rituals, and they will regulate the objectionable elements. The stance of the petitioners is that these rituals are no longer being conducted in their original form, and now they have taken the turn of animal cruelty. However, Your Lordship, that's why we have brought these regulations, so that these rituals can be conducted in the same form in which they were being conducted since time immemorial, which is by eliminating any form of cruelty to animals. Your Lordship, the petitioners also contended that these practices are...
You are referring to your custom.
Indeed, Your Lordship.
Right. What do you mean by custom?
Your Lordship, custom can be defined as something which has been practiced for a very long period of time by a set community of people, so much so that it has become a part of their everyday practice. Thank you, Your Lordship. Moving forward, Your Lordship, the petitioners contended that these practices have turned into a money-making practice under the garb of cultural ritual. And the foundation of their argument rests on the fact that registration is required for these events. However, Your Lordship, just because registration is required, it cannot be assumed that money and sale of tickets is involved. Registrations were being done for management purpose, which is for efficient handling of these rituals, such that how many animals are participating, the caretakers of the animals, identifying and serially numbering the animals with their caretaker, and also for managing the number of participants. Your Lordship, if the Council seeks permission to proceed with issue 3.
Yes.
Much obliged, Your Lordship. Your Lordship, with issue 3, the Council most humbly submits that government's decision to impose internet bans was justifiable under Article 19, Clause 2 on the grounds of public order. The Council has two-pronged arguments for the same. First is the prevailing circumstance do meet the requirement for imposition of restriction, and censoring of viral videos was warranted to mitigate the risk of inciting further public unrest. Your Lordship, moving forward with the first prong, the constitutional validity of every restriction on speech and expression is tested against 3 standards, which are whether this restriction was imposed under law, if these restrictions were in pursuance of the 9 items which are listed under Article 19, Clause 2, and if these restrictions are reasonable. Your Lordship, the restriction was imposed under Section 163 of Indica Nagarik Suraksha Sanhita, a section which empowers the district magistrate to impose bans on public gathering and also impose internet bans. Your Lordship, this
according to you, which restriction under 19.2 are applicable to the present case?
Indeed, Your Lordship, 19.2 lists out 19 restrictions, and for our case,
specific,
public order.
There are several restrictions.
Indeed.
Which restrictions are specifically applicable to the present case?
Indeed, Your Lordship. For our case, restrictions was placed in interest of public order.
How it violates public order?
Your Lordship, in the case of Superintendent of Central Prison versus Ram Manohar Lohia, I may briefly summarize the case. It was a case in which Section 3 of...
Once you say that this is a part of a ritual or a custom, and you say that this is against public order, is it not mutually destructive argument? Public order once you say that this is part of ritual and custom.
Your Lordship, the rituals are part of culture. However, the public unrest which took place, and to suppress that, we had imposed Section 163. Orders under Section 163 to the states. The public unrest was not caused of the rituals. However, it was because of the videos which was uploaded, and that led to public violence and destruction of property. And to curb that, we had imposed Section 163.
So there is no cruelty to the animals. According to you, there is no cruelty to animals?
Your Lordship, definitely that in the preceding, the way these rituals have been followed, there was cruelty. However, the state under its responsibility has brought the regulation to prevent further cruelty to the animals.
No, that means you are arguing again against you. One hand was said is cruelty. Second hand is their publicity. And if the cruelty publicity goes together, then you are hitting the provision.
Your Lordship, could you please repeat the question?
We are saying you are arguing against you also. If you say one hand there is cruelty, and on the other hand you are saying that there is publicity, therefore you impose restriction, then how can you substantiate this end?
Your Lordship, understood your question, Your Lordship. Your Lordship, these rituals were being performed. However, the public unrest which took place, it was not because of these rituals. The public unrest took place because Mr. Deshmukh, he uploaded a video on the internet.
Video of what? Video of that situation?
In the video, it was shown that animals were treated cruelly. And that led to dissent between animal rights activists and cultural defenders. And in that, in public dissent, the public unrest took place. It was not because of the rituals, Your Lordship. There was no cases of any public unrest while the rituals were taking place. It was
that was source.
Was afterwards.
That was the source. That was uploaded. What are you saying? If that rituals was going on, that wasn't uploaded by video, then in that case, that was the source.
Your Lordship,
Source. If that is the source, then how can you disclose that question?
Your Lordship, even the video which was uploaded, it was not of the ritual taking place.
Then?
The video uploaded, if Your Lordship may refer to para 6 of the Moot proposition, it was footage of bulls being beaten and tortured to make more aggressive. However, it was done by the caretakers of the bull. The video did not pertain to the ritual actually taking place, Your Lordship.
Why they were brutally beaten by their caretakers?
Your Lordship, because the brutality was being taken place to make the animals more aggressive.
More aggressive, that's for what? More aggressive for what?
So does it not cruelty?
That's why this.
By the owner of the animals, only when they are beaten by the public, that will be cruelty. By the owner, it will not be cruelty.
No, Your Lordship. Even if they are beaten by the caretakers,
no,
it amounts.
I had given an example to the petition number 2. With regard to that bullocks which have been utilized for the purpose of plowing, if the farmer gives some
Beats the bullock in the process.
beats a bullock and it creates it does not create an impression that is cruelty towards animal.
Yes, Your Lordship, that is cruelty towards animal, and for that, the prevention of cruelty to animals has a specific section. Section 3 of the Act states that it's the responsibility of the person who is in care of the animal to take all reasonable measures to prevent unnecessary, to promote well-being and take all reasonable measures so that no unnecessary harm is inflicted on the animals.
Does it apply to your case? Because your argument is that the caretakers have beaten to the bullocks to make it more aggressive so that they will participate in the
That's sports event.
Understood, Your Lordship. Your Lordship, for that, the council will answer that these rituals, they might be an ancient form of rituals. However, in course of time, this beating and cruelty was introduced in those rituals. And seeing these as violative of Prevention to Cruelty Act, the state did bring regulation, which was
when the PCA Act came into force.
Your Lordship, it came into force in 1960.
1960. Prior to that, this system was there.
Your Lordship,
Your contention is 500 old culture.
That is your case. That it's a 500-year-old tradition.
500-year-old case. Then when the Act came into force in 1960,
Indeed, Your Lordship.
whether you will abide by the provisions of law or you will go by the tradition.
Your Lordship, if you could please repeat the question. There was some reception problem on my side.
All right. If you say that it is a 500 years old tradition, whether the 5 years old tradition will override the provisions contained in the Act which are promulgated in 1960?
Your Lordship, no, the tradition cannot override the 1960 Act.
If it is not, then how can you say that the bullock is made aggressive by his owner to participate in the cultural program?
Indeed, that's why, Your Lordship, the council stated.
By cruelty?
Indeed, Your Lordship. Your Lordship, the council did state that these practices, though they were age-old practices, however, these infliction of cruelty and unnecessary pain, this was introduced by humans in recent significant times. Therefore, in order to make sure that these rituals go back to their old times in the original form in which they were practiced, that's why the state has brought regulation which will regulate these offensive practices which are being treated, which are being given to those animals.
That's not our question. Question is, your argument is that this is a 500-year-old tradition. That tradition
Yes,
are
Your Lordship.
following, and that is why these rituals are being performed. Right?
Yes, Your Lordship. Yes, Your Lordship.
To follow that rituals, the caretakers are showing cruelty to make the bullock aggressive so that they can participate in the process. Our question is that if the 500 years old tradition, can it be used to override the act which was framed in 1960, number one? If it overrides 1960 Act, then why such a restriction is put under the Act that you should not show cruelty to the animal?
Understood, Your Lordship. Your Lordship, to answer your first question, the culture will not override the 1960 Act. And Your Lordship, as for your second question, that if they cannot override Act, why cruelty is why the animals are being subjected to cruelty? Your Lordship, it is because these rituals are not being performed in their original form. The rituals in the original form, they did not involve cruelty to animals. However, in recent times, it's a
when? After commencement of the Act 1960 or prior to that?
No. After commencement of the Act, Your Lordship.
Recent times was
after commencement of yes, after commencement of the Act, the state would see and Your Lordship, there is no specific date in the proposition. And after the commencement of the Act, there were incidents of animal cruelty, meaning the humans had changed the rituals to suit their form, and the state brought these regulations so that these rituals can go back to their original form, which is when such cruel practices were not being practiced. Such harm and cruelty was not being inflicted to the animals.
When this regulation came into force?
Your Lordship, in the Moot proposition para 9, it states that the Ranthara Sports Regulation Act came in 2024 and the Dharmaja Cultural Heritage Act came in 2023.
So these are in consonance with the provisions contained in 1960 Act.
Indeed, Your Lordship. As stated by my co-counsel, the Prevention of Cruelty to Animals Act is a central act, and every state has its own religious and ritual practices. It would have been difficult for the central government to encompass every practice and regulate every practice within the framework of the central act. That's why these two state acts will further regulate these rituals so that unnecessary pain and harm is not inflicted to the animals.
All right.
Much obliged, Your Lordship. Your Lordship, moving forward with issue 3, Your Lordship, as the council stated that the constitutional validity will be tested against 3 standards. The first standard is that whether the restriction imposed under Section 163 of Indica Nagarik Suraksha Sanhita was reasonable. Your Lordship, an order under this section can be exercised in cases of emergency when there are obstruction or injury to person, danger to human life, health or safety, or disturbance to public tranquility. Your Lordship, the relevance of this section lies in urgency, which means if any of the preceding three events happen and the harm is sudden, imminent, or anticipated, an order under 163 can be passed. If your Lordship may kindly refer to para 8 of the Moot proposition, shortly after the documentary was uploaded, there was outrage and violent clashes erupted in the states of Randhara and Dharmaja. It also led to injuries and widespread property damage. It was to curb these mishaps. The state imposed prohibitory orders under Section 163. The next standard is that of Article 19, Clause 2. Your Lordship, for us, the restriction in interest of public order is relevant. Your Lordship, in the case of Superintendent of Central Prison versus Ram Manohar Lohia, the council will briefly state the facts. The case was of Section 3 of a UP Act, which stated that if anyone gives any insightful speech which will prevent others from paying their liability or debts, they shall be arrested. And it was validity of this section which was challenged under the court. And in this regard, the court gave definition of public order, which is relevant for the present case. Your Lordship, the court has defined public order as orderly state of society in which citizens can peacefully pursue the normal activities of life.
So what is the meaning of what is the distinction between public order and law and order?
Your Lordship, the council seeks permission to differentiate with the help of an example which was given by Justice Hidayatullah in this very case. Your Lordship, Justice Hidayatullah said that in case two families are fighting for irrigation, it would be a breach of law and order. However, if two communities are fighting for irrigation, it would be breach of public order.
Yes. So what is the thin line distinction?
Your Lordship, could you
Thin
please?
line distinction. Thin line distinction between two is?
Your Lordship, the thin line distinction would be violation of law. Like if two neighbors are fighting, it would come under their private dispute. However, if public order is breached, that would be violation of law, which is happening here because there is public injury and damage to property.
All right. One is
Moving
individual,
forward,
the other is society at large. Broader classification.
Indeed, Your Lordship. Yes, Your Lordship. So the court has defined public order where public can peacefully continue with normal practices of their life, and it is absence of disorder involving local breaches. So therefore, Your Lordship, there were widespread clashes, violent clashes and damage to property, meaning there was definitely breach of public order. Your Lordship, the next and the most important standard is that of reasonability, that the order must be reasonable. Your Lordship, reasonability of internet bans is tested against the proportionality test, which was laid down in the case by this honorable court in the case of Anuradha Bhasin versus Union of India. The citation for the case is AIR 2020, Supreme Court, page number 1308. Your Lordship, the requirement of doctrine of proportionality is threefold, which are the order must be legitimate, not arbitrary. It should have direct and proximate nexus to the object sought, and alternative measures should have been assessed by the state. Your Lordship, firstly, the goal of maintaining public order in the midst of violent public unrest is undeniably legitimate because by banning public gathering and banning spread of videos through internet, which was the major cause of the unrest, and given the immediacy of the threat which was posed by is there a question, Your Lordship?
No, go ahead.
Apologies, Your Lordship. is the threat which was posed by spread of content. This was the least restrictive option available to the state. Your Lordship, this measure was not arbitrary. It was necessary so that to prevent potential further escalation of the matter. By imposing internet ban, the state tried to prevent access to inflammatory content. Reasonableness of a restriction is determined in objective manner and should be from the standpoint of general public. Therefore, in judging the validity of the restriction, and it was in interest of general public that we imposed orders. Your Lordship, the counsels for petitioners have contended that internet ban did not have direct or proximate nexus. However, Your Lordship, internet is a medium through which information, mostly in cases of riots, are most easily spread. Therefore, an immediate shutdown was required to prevent access and information from reaching to the public. Therefore, the order was legitimate. It did have proximate nexus, and other less restrictive measures were not available given the immediacy of the situation. Your Lordship, lastly, censoring of the viral videos was warranted because the Honorable Court in the case of K. Abbas versus Union of India has held that motion pictures should be approached differently than other form of speech and expression because pictures have the ability to invoke emotions more profoundly. Your Lordship, there have been various instances of video censorship globally. For example, the videos for civil war in Syria were uploaded on YouTube. Those videos were promptly taken down because they did incite public feelings and they were not in line with morality and public order. Furthermore, Your Lordship, even Facebook deleted photos of abuses which were done by the Myanmar government in the then
Your time is over. Your time is over.
Your Lordship, the council seeks extension of 2 minutes to wrap up the arguments.
All right.
Indeed, Your Lordship. Yes, Your Lordship. Therefore, censoring of viral videos was warranted. Your Lordship, issue 4 deals with whether the order to ban public gathering under Section 163 was valid. Your Lordship, as stated by the council before, an order under 163 is imposed in case of urgency when there is harm to public health, life, and injury, which is being satisfied in this case. Also, this court has held the powers under Section 163 are not only remedial but also preventive. So, to prevent further escalation of matters, the orders under 163 were passed. Your Lordship, and the general order was necessary because the number of persons who were being affected by these violence was so large that a distinction could not be made between specific person and general public. So given the immediacy of the situation, a general order was passed. And also this order under Section 163, it passes the test of proportionality, which was laid down by this court in the case of Anuradha Bhasin. Your Lordship, also there is an international standard of proportionality, which was laid down by the Canada Supreme Court in the case of R versus Oaks. The tests are exactly the same, that order must be legitimate, it must have proximate nexus, and alternate measures should be assessed. So therefore, the orders also fulfill the international standard. And Your Lordship, to conclude the argument,
one more question. Whether the order passed under Section 144 CRPC is an administrative order or a judicial order?
It's an administrative order, Your Lordship.
What is the test of an order become an administrative one?
Your Lordship, when it's passed by the executive, like in this case, the order was passed by the district magistrate.
Only that?
Your Lordship, the council is aware of this. Much obliged, Your Lordship. Your Lordship, and concluding, Your Lordship, it has been a stance of this course that in cases of emergency and urgency, private rights should give way to public interest. And in interest of public interest, we had imposed the order. Therefore, Your Lordship, the order imposed was reasonable. Your Lordship, the council seeks permission to move forward with prayer.
Yeah.
Much obliged, Your Lordship. Wherefore, in the light of issues raised, arguments advanced, and authorities cited, may this honorable court be placed to adjudge and declare that the state regulations were not violative of provisions of Prevention of Cruelty to Animals Act, and they are in consonance with provisions of Constitution of Indica, that the bull rituals in these states are protected as cultural rights, and they will not override the duty to prevent animal cruelty, that the state government's decision to impose internet bans and censor viral videos was justified in the Article 19 on grounds of maintaining public order, that the imposition of Section 163 was proportionate and not abuse of power, and that provisions of Prevention of Cruelty to Animals Act are sufficient to address the issue of animal cruelty and provide adequate punishment and requires no amendment. And in light of all these issues raised, dismiss the petition with cost and or pass any order which it deems fit in the interest of justice, equity, and good conscience. All of which is most humbly and respectfully submitted on behalf of the respondent.
Okay.
Thank you, Your Lordship. It was an honor to argue before the court.
Thank you. Any reply?
Yes, Your Lordship.
Yeah.
Yes, Your Lordship. Your Lordship, regarding the respondent has submitted certain submissions, like they have said that to determine that it is an essential practice. Again, repeatedly they have said that this is a religious practice or a cultural practice. Again, I would like to reiterate that to determine what is essential in the case of Commissioner versus Sri Sirur Mutt, citation is 1954 SCR 1005, emphasize the importance of the religious doctrine in order to ascertain what constitutes an essential religious practice. Also, in the case of Sardar Saifuddin versus State of Bombay, citation AIR 1962 SCR 895, the court emphasized that the essential religious practices are to be determined by the text. And Your Lordship, I have cited many things where our text has said that we should have compassion towards the animal. If we see the Buddha Charitam, it says that Jivesu Karuna Chapi Maitritesu Vidaitam, be compassionate and friendly to all living beings. So this is our culture. Our culture is not about hurting or inflicting injury or cruelty to animals. Your Lordship, they have also said that under Article 25, they are saying, and Article 26, they have said that this is they are protected under this. Your Lordship, I would like to reiterate that freedom of consent and free profession, practice and propagation of religion is subject to public order, morality, and health. Your Lordship, the three rituals here which has been involved, I would like you to refer to our proposition paragraph number 3, Your Lordship. 3, Your Lordship, and 4 also. In paragraph number 4, it has been said that the trampling ritual held the day after Diwali, the spectacle of devotees lying on the ground for bulls to trample over them. Isn't it subject to come under the ambit that is under the health that has been given under Article 25 of the Constitution? Your Lordship, again, if we come about Article 25, that it has said about public order. Your Lordship, my learned respondent, speaker number 2, has already stated that under while addressing issue number 4, that is because there were clashes between the parties. As also Your Lordship asked, what is the difference between the law and order and public order? And under that, it is said that public order has already been disturbed. There were clashes which has already been mentioned in our facts also. So that means the public order is already disturbed. So clashes are outbroke, and it is an accepted fact by the respondent that it is violative of the public order. The public order is violated because of these 3 rituals. Also, they also said that the videos that was given was not of that particular rituals. I would like to draw your attention to para 6 of the proposition, Your Lordship. The video was about the rituals only. I am stating it, in 2024, an investigative journalist, Arun Desmukh, managed to infiltrate these festivals, and film the backstage brutality inflicted on the animals before the events. His short documentary uploaded on social media platform included distressing footage of bulls being beaten, whipped, tortured to make them more aggressive. Your Lordship, this cannot be said that these were not a part of rituals. This is a preparation for the rituals. Then if we say that preparation for crime is also a crime, then how can the preparation for the ritual cannot be included, that treated as ritual also? Hence, I would request your lordship that this preparation shall also be treated as a part of this ritual. Also, your lordship, I would like to say, draw your attention to regarding the internet ban. Your lordship, there are provision under section 69 of the IT Act, which says they could have asked the intermediaries, or they could have passed direction to the intermediaries like the social media to take down the particular videos they could have taken down. Then why there was a need to ban, complete ban
Your
on the
time is
internet?
over.
That means,
Your time is over.
let me know. They have banned the internet so that they could suppress the decision, your lordship. Much obliged.
Justice Mohapatra, to say something to these participants.
Certainly, sure, Lordship. Your Lordship, the council.
No further argument. No further argument.
The
Yeah.
council.
So case from both sides it raised.
Your Lordship.
More or less, we are very happy with your performance. So that
Your Lordship, do I have the permission to sorry, but
The judge, just 1 minute. Yes, Mr. Mohapatra, you just say something to these students.
It's already the discretion of the court. They haven't allowed you.
Yes, Justice Mohapatra, you just tell something to the students.
So we are happy with your preparation and presentation of case. I really appreciate your effort. That's all.
All right, thank you, Brother Justice Mohapatra. I congratulate each of the participants who have prepared well, presented well. Who will succeed, who will lose, that's not the question. The question is, it is a stepping stone for your future. And if somebody wants to join litigation side, it will help you a lot. Therefore, the preparation which has been done, it should continue, and you should come out as a bright lawyer for future. And I hope and trust that you will not disappoint us tomorrow, saying that, sir, we have not prepared, therefore will not argue the matter. Whenever occasion comes to you, avail it, explore it, and satisfy to the court, and say that, yes, I am prepared, I will do the case, so that you will have the impact in the court itself. And court is also a human being. If you carry an impression in the courtroom saying that, yes, I am prepared, court will automatically find out ways and means how to give relief to you. So may God bless you all, and you must succeed your life. Thank you all.
Honorable judges and esteemed committee members and the participants, it is both a privilege and a pleasure to extend our heartfelt gratitude from behalf of the committee to everyone who contributed in making this national level moot court competition and invaluable experiences for our students. Firstly, on behalf of everyone present, I extend my sincerest thanks to our distinguished judges. Thank you for sparing your time and precious time to be with us, especially for adjudicating the final round of the moot court. Your expertise and insights have not only raised the standards of this competition, but have also given us invaluable lessons in the art of argument and legal reasoning. Your encouragement and the constructive feedback are immensely valuable as we swear to pursue careers in the legal field. We also owe a deep debt of gratitude to the organizing committee for their tireless efforts to the planning and conducting of this event. To conclude, I express our gratitude to all the participants for making this competition vibrant and inspiring. It is indeed a special occasion made memorable and a collective efforts of everyone involved. Thank you, Your Lordships, and thank you to all the participants.
Thank you.
Sir, on behalf of AKM 62, sir, it was an honor arguing before you both. So we were very delighted to argue before you.
And then don't take our interventions otherwise. I can be more harsh in court. So it was just educative to teach you, to make you learn
Indeed, Your Lordship.
the court
Indeed,
procedure.
Your Lordship.
So
Thank you,
don't
sir.
remain under that impression. When you appear before the court, sometimes the court can be more harsh on you.
Indeed, Your Lordship.
So you should get used to that.
We would face that sometime in our life, surely.
But don't lose your presence.
Yeah.
Even if court become harsh on you,
Court may lose, yes. Court has that discretion.
don't lose your
That,
presence, and with boldness you argue the matter so that you will succeed like anything. Right? Success
Sure, yeah.
never comes to your hand automatically. It requires a perseverance.
Much
So-
obliged, Your Lordship.
Your perseverance is highly essential, and we are very happy that the future of the judiciary is in safe
right,
hands.
right. It's very bright. with you all.
Thank you so much. Thank
It
you.
is safe.
Thank you, Your Lordship.
Thank you. Thank you.
Much obliged, Your Lordships.
God bless you.
Thank you, Your Lordships. Thank you to all the participants.
Just Mohapatra, just remain in the screen so that we can discuss.
All right.
All the participants, you may leave.
Participant delete.
Sir, actually, YouTube live, live video all over India.